I'm going to do an overview of the case and the settlement. I'm going to ask a couple of individuals to come forward and speak about particular pieces of the settlement, about which they are more familiar than I am. And then we're going to take a break, and I'm going to ask you to write down questions so that we can answer as many questions as we can in about 20 minutes. It's not very long, but because of this deadline problem with having to be out by 8 o'clock, I want to be sure to answer as many questions as we can. I also wanted to let you know that the water masters for this valley are here today. And so if you have particular questions that you want to ask of them, they are here. I'm not sure that we got Wi-Fi. They did bring computers to look up RG numbers and that kind of thing for you. But I would encourage you to come to the workshops. So for the next 7 weeks, from now until April 5th, I will be holding workshops on Tuesdays and Thursday evenings from 6 until 8. On Wednesday from 6 until 8, I'll be at the Pojoaque the Pojoaque satellite office, and for office hours, and the same on Saturday from 10 to 2. So we're hoping that by giving this range of availability of my time, that I'll be able to assist you with any questions that you might have, and perhaps you feel more comfortable asking in a more private or smaller situation. I also have had some PSA announcements and a radio show, and there will be some press to advertise these meetings and to get the word out to people. Before I go too much further, I do want to tell you that in the inside cover of the handbook are the dates and times and places of the workshops and the office hours. On the very front of the page, the very front cover, is all of my contact information. I think I mentioned that. Before I go much further, I want to introduce the lawyers and technical people who are here today so that you can A, lay an eye upon them, and B, you'll be able to ask some of them questions during the break and like that. So, I can't see that far away. Ted Bagley is at the far end. Ted, would you please stand? Ted is an attorney for the state, and he will introduce the other people who are here with him from the state. Okay.
I think Darcy wants me to repeat what I said from over there and introduce the attorneys who are with me from the state. With me is Ariane Singer, who's the head of the Northern New Mexico team, which is the team that does the Aamodt lawsuit for the state of New Mexico. And Misty Braswell, who's also an attorney on the Northern New Mexico team, who's done some work, who works on the Aamodt case as well. Oh, I'm sorry. We also have with us, I apologize, Brian Gallegos and Vince Chavez over there who work for Water Rights Division, and Steve Mastovich also, who are here. Sorry, I'm getting a little feedback, but who are here to answer questions about the lawsuit. And I think have brought their computers with them so that we can try to look up water rights information online if that's helpful to folks tonight.
Maria? Do I see Maria? Oh, over there. Okay. Magil, you get elected to introduce the Pueblo Council, please. This is Magil Russell, and she represents Tesuque. Magil, sorry.
Yes. I'm Magil Russell. I'm the attorney for the Tesuque Pueblo. And for attorneys for the Pueblos tonight, we have Maria O'Brien representing Pojoaque and Peter Chestnut representing San Ildefonso. And I don't see, I think that's it for the Pueblo attorneys. Thank you.
Thank you. Gus, please come forward. Chris is going to come forward. All right. These fellows represent the United States.
Hi, everybody. I'm Chris Benet. I'm with the Bureau of Indian Affairs. I'm not an attorney, so there you go. But I am one of the federales. So I want to introduce Gus Guarino, the U.S. Attorney from Denver. Kathy Dickinson, Bureau of Reclamation, and Art Valverde, Reclamation. And I think that's the U.S. team.
And then we have Larry White, who represents people in Tesuque. Larry?
Good evening. I'm Larry White. I represent the community of Seikis and Tesuque primarily, and I've been actually involved in this case since about 1976, continuously. So.
All right, have I missed anyone? Oh, Claudia. Very sorry. Claudia, come forward, please. Claudia is the new head of public utilities for the county of Santa Fe. She will also be introducing other people who are here from the county.
Hello and welcome. We have Commissioner Mayfield here. Stand up, okay. We have Commissioner Holian, who's moved. There she is. Okay. Part of the team that's working on this on our behalf is John Utton, who is our attorney. And we have Robert George, who is our utilities infrastructure manager. And Adam Leegland is back talking on the phone. And we believe any moment our county manager, Catherine Miller, will also be arriving. So that's the county team.
So I have been hired by the county to make a lot of noise, to conduct these meetings. I did a series of 14 meetings in 2010. They were smaller meetings, about 30 people per, and they were designed to help people get sufficient information that they could make decisions and understand what was happening in terms of the Indians' water rights, their own water rights, and future developments in the valley that involve the Aamodt water case. The case was filed in 1966. We're coming up on the 48th birthday or anniversary on April 20th. And it's not the oldest case. It's the oldest active federal case in the nation. And the oldest case is actually, not in the nation, but in New Mexico, is the Chama adjudication, which is also in federal court, and it was filed in 1948. The Pecos case was filed in 1956. This does not mean that we don't want to finish this one. The background of this case is that it was filed so that the state engineer could have a sense of how much water was available and how to manage water with the new San Juan Chama water coming in. San Juan Chama represents that water that New Mexico is entitled to from the Colorado River. And it comes from some tributaries in Colorado down through some enormous tunnels and into the Chama River system and into those reservoirs. The Aamodt case, as I said, was filed in 66. By 1969, most of the surface water rights were finished. They had been adjudicated except for the priority dates. In the mid-'80s, they started working on wells. It's hard to find wells, and it's hard to identify where they are, especially when you don't have computers and you don't have aerial photography so you can find houses and things like that. So it has taken a very long time to kind of work through just the non-Indians' water rights. And today, the surface water rights are pretty well done, just a couple of priority dates to finish up. The wells are getting very well done. Of course, they keep multiplying, so that makes life exciting. And the adjudication of the Indians' water rights started in about 1970-ish. And they were litigated. They were in trial for 30 years. In 30 years, the party said, guess what? This isn't working. We're really tired. This isn't working. So they decided to try settlement. And settlement is actually something that the federal government supports for tribal water rights. And I'll get into that a little bit more in a minute. The notion of adjudication, the goal of adjudication, is to identify all the uses in a particular watershed and to formalize them so that there is sufficient information available for property owners to know what they own. And for the state engineer to be able to manage water, and which is his responsibility under our laws. The whole concept of adjudication is in our laws. The state engineer is required to do this. And so is not doing it because they love doing it and need a job. They're doing it because the statutes require it of them. The information that is gathered through these processes helps the state engineer understand in times of shortage how to manage the water. And it also helps the state engineer to have a rational basis for agreeing to let more development in a particular area. So let's say there's an area that only has a bit of water available generally most years. Or maybe there's a certain amount of water that's available in a groundwater system. The state engineer has to have a rational basis for saying, yes, there can be more development, or no, there cannot. And these adjudications help them get to that place. These processes are taking place across the West and across New Mexico. There are 12 of these going on in New Mexico today. The oldest case I ever heard of, and this was several years ago I heard of it, so it's even older now, but that was in Washington, and it was 75 years old. It would be so nice not to be here in 25 years thinking about this some more. But if we have to, we will. So, the general rule for how adjudication works, and many of you know this already, but many of you are new to the system, or to the valley. You gather information about water use and entitlement, and you put together an abstract that describes that water use and that entitlement. And for non-Indians, the state engineer gathers together all the information it has in the public record, puts it together, and sends it to you in an offer of judgment, or a consent order, or a subfile order, a lot of different names for it. There's basically a proposed order, describes your water right. There's a map with it, so you can see, oh yeah, that's my house, or no, that's George's house. You're sending this to the wrong person. And there may be some informal negotiation that goes on between yourself and the state engineer. You might have to go to trial, although I got to tell you, I can count on one hand the number of trials I've seen. And when that's done, the court signs an order that resolves the matter as between the state and yourself. And then under our system of adjudication, there is a process called inter se, Latin for among each other. And that's when the community has an opportunity to step up and say, hey, I know that's what you thought it was, but we don't think so. Or, yeah, that looks okay, we're not going to worry about that. And that's where we are today for the tribal members who live here, the tribal communities who live here in the valley. In 2000, after those 30 years of litigation, they sat down at the table and they worked out a settlement that involves the description of their water rights, and they gave up some things, they got some things, and at that table were non-Indians, the city of Santa Fe, the county of Santa Fe, the United States, which doesn't actually participate until Congress says, go for it. And they knocked out this settlement agreement. They took it to the community said, no dice, there's something wrong here. So they went back to the table, they worked it out, and in 2006, they took it to Congress. And Congress worked on it for 4 years. That's when the feds started getting involved in it. And they came up with the act. So the settlement agreement is among parties who were at the table. And the act is Congress saying, okay, not only does this look all right, but we'll fund it. We'll put some money into it. There's a wide range of things that tribes can negotiate. They will negotiate in part because litigation can be a total loss, or they can get a huge amount of water. But they don't oftentimes have the wherewithal to put that water to use. So when they sit down at the table, they can say things like, I'll give up this kind of claim, or this amount of water, or this right that I might have to challenge other people's rights. I'll give that up if we can have money to build, in this case, a rural water system. Now, if you want to get into the details of what they gave up and what they got, that's in your handbook. Take a look at that. There's also some stuff in the frequently asked questions. Let me get a drink of water. Water! Water! All right, so this tribe, these 3 or 4 tribes sat down, the Pueblos sat down, and they said, we would like more water in the valley. We would like to have a good delivery system. We would like to have clean, potable water. We would like our water rights defined. Typically, throughout the West, tribal rights are the oldest rights, and therefore, in a prior appropriation system, they come first during times of shortage. This is across the West. This is sort of the bottom line. If you can't work out how else you're going to share water, this is where we're going to go. So you take everybody, and you line them up by their priority date. These up here, the oldest ones, they're called seniors. These down here are called juniors. And you start curtailing or shutting down junior uses until there's sufficient water in time of shortage only, so that those seniors can be served. And in our Constitution, it says that seniors will be taken care of. It actually says priority gives you the better right, but that's what it means. Seniors will be taken care of. So who are seniors? Well, the Pueblos are seniors. But so are Acequias. So are pre-basin wells. So is the guy who drilled his well last year. When you compare his water right to her water right, water right that was developed yesterday. So it's relative. And one of the things in this settlement that the Pueblos asked for and the other parties agreed to was bringing in an additional 4,000 acre feet through the Rio Grande into the valley. This is water that does not presently exist in this valley. The concept here is to make the pie larger so that the Pueblos can get their rights, but the senior rights are being preserved and protected. And the likelihood of them having to be curtailed during times of shortage is reduced. It is not a promise. There will be shortages, or there may be. My crystal ball is good on this. That people in the valley will be asked to cut back. Like in Albuquerque, I'm asked to only water on certain days of the week because there's not enough water during these drought times to service everyone watering every day, or maybe taking showers every other day, or whatever it might be. Not, in Las Vegas, New Mexico, People are not allowed to water outdoors, period, end of story, no car washing, all that kind of thing. There simply isn't enough water. So this settlement brings in 4,000 acre feet. Will it always be there every year? No, it won't. But to the extent that it is, it supplements what you already have, and it protects what you already have. Another thing they wanted out of this settlement was an end to the litigation. If this settlement goes through, the litigation will end in September 15, 2017. Certain things have to happen, and those are laid out in the Act and in the settlement agreement. Those things are identified. And the parties have made pretty good progress towards a number of these things. So the cost share and system integration system agreement has been finalized. You can get it on my website if you want to look at that. There is a joint powers agreement that talks about how the, I don't like not being able to move around, and so I'm kind of distracted by that. This joint powers agreement talks about how the regional water system will be managed, and John Upton is going to go into that in a little more detail. It talks about, another document is the New Mexico water rights, water master rules and regulations. The joint powers agreement is in progress right now. So they're working on the draft. There will be an opportunity for public input, comment on that document. The water master rules are being drafted. They're tricky. It's going to take a little time. But they're being worked on, and there will be public input. And then after the system is built, or closer to being built than we are today, the operating agreement will be put together. That's a little bit further down the road. So where are we today? We've got the settlement, we've got the Act. The Act talks about federal money, it talks about state money. Those two documents are summarized in the next thing that happened, which is the order to show cause. Court signed that in December and sent the United States, now this is going to be confusing, but I'll work it out for you. The court told the United States to send it out with a return address of the state. Okay? 6,000 of these went out. And before they went out, the state, as required by the court, filed a mailing list. And community members and others said, that mailing list, not so hot. So the United States paid the postal office to update it. And they did what they could with it. And still many people did not get the packet with the order to show cause, the acceptance form, and the objection form. If you need that, you can get, I have many copies here of the packet. There are copies at the Pojoaque Satellite Office. You can download them off of my website and Commissioner Mayfield's website, and you can pick them up at the State Engineer's Office. There will not be another mailing of that packet, as I understand it, but we're trying to make it available to you at these meetings, at the workshops, and online, and at public locations. So, why didn't you get a packet? Well, possibly the ownership of your well or your tract of land hasn't been updated. Possibly the post office didn't have another address for you, or at least one that could be found by the people who did it. Possibly you don't have a water right. If you have a tract of land, but you have not developed a well or used water on it to irrigate it, you don't have a water right. And why is that? Because under our Constitution, you have to put water to beneficial use to create a water right. Beneficial use is the measure, the limit, and the basis of water rights in New Mexico. And so if you've not developed a water right yet, you don't have one. This is important to take note of because, I'm doing a sidetrack, okay? It's important to take note of because part of the settlement is a recognition that all the water that is currently available in the valley has been fully appropriated. That is, it's being used by somebody. And the basin will close, and there will not be new wells allowed, permitted, except under certain circumstances. And so what that is going to do, that provision of the settlement, what it will do is it will protect the groundwater so that the water table has a chance of coming back up, supporting water in the streams so that the acequias can irrigate, and protecting the senior users of groundwater from new appropriations so that their wells don't go dry unless there's a drought, a really bad drought. Because I hear you have a good water table here. But the idea is to protect that water table for future generations and for the people who are already here. Enter the water system. So the water system is a really important, the regional water system is a really important piece of the settlement. The water system is designed to serve the Pueblos. It will be built by the Bureau of Reclamation. And the county, as it was sitting at the table, said, hey, you know, we really would like an opportunity to make this water system available to county residents if they'd like it. And the Pueblo said, okay. And the feds said, okay. And so the county today has an opportunity to build out this water system. One of the important things about this water system is it brings fire protection to the valley. And the county feels that that's real important to this valley to have fire protection, water for fire protection. So, looping back to the order to show cause, which summarizes the act and the settlement agreement in the interim administrative order, which tells you how water is going to be managed between now and the end of the settlement process, whether it's accepted or not, the end of the settlement process. And under that order to show cause, the court has said to everyone who is a water owner in the valley, you must either accept or object to this proposed decree, which describes the tribe's water rights, the settlement agreement, and the proposed interim order. And am I missing one? I hear nothing from the peanut gallery. So, proposed decree, settlement agreement, interim order. And along with this order to show cause, which is basically the court saying to you, show me why this oughtn't be so. Show me why I shouldn't adopt this. We had the acceptance and the objection. Now, this is very important. If you wish to object to the settlement, or you wish to object to any of that package of documents, you must have it done and filed with the court by April 7th. If you are going to accept the settlement and you don't really know which way you're going to go, that's fine. You do not have to file your acceptance until a later date. When you say, well, 30 days after the 7th of April, the parties have to give the court a proposed order about how the objection phase and the rest of the case will unfold. And it's my hope that it's in that document that the court should file in roughly May, June of this year that will tell us when the acceptances, and for those of you who have wells, have to make your election with regard to your well.
How much time do we have for that?
We don't know yet, but we hope that in that order, we will be told. And we suspect that we will be told in that order. So sort of one of the important things, one of the take-home messages here is pay attention, keep an eye on the various outlets for information, because more is coming. More opportunities to participate, more information about deadlines, that kind of thing. All right, so we got our acceptance, we've got our objection. If you object, the court tells you in that document, in general terms, what you have to show. You can't just say, I don't like it. It's not fair. Courts can't react to those kinds of statements. You need to say more. You need to say why it hurts you, or look at that information that the court gives you about the standard it's going to be using to evaluate any kind of objection that you make. If you choose not to object, you will be in a class of people called acceptors. But the court wants you to affirmatively, if you're going to accept, the court wants you to file something. And that would be the acceptance form. I'm talking about everybody. All the non-tribal members who own a water right have to either file an objection or they have to file an acceptance.
And we don't need a lawyer to file.
I've seen many of these cases, and I've seen a whole lot more people who represent themselves than people who hire lawyers. It's really an individual choice. It is possible, but you have to do what feels right to you. All right.
Excuse me, ma'am.
Yes, sir.
Whatever happened to the treaty at Diablo? Because that treaty had all the water rights settled.
That is a legal question the court will have to answer. And I am not able to answer that question tonight.
Because that's against the constitutional right.
I'm sorry, I'm going to ask you to write down your questions. Questions that have to do with legal issues like Treaty of Guadalupe Hidalgo, I can't answer tonight. For one thing, I can't practice law, and legal questions involve practicing law. So that is a question to take to the court rather than a public forum. It is a question that comes up, and I've heard it for many years here. And there is a place for that question to be asked and answered. And that is with the court. All right. If you wait just a second. I've gone over my time a bit. Hold on, please. I'm going to ask us to take a little break right now because my voice is dying. And because I have sheets available here for you to sign up for workshops or for office hours. And I have paper and pencil for you to write down questions that you have so that I can bring them to individuals or answer them myself if I know the answer. If you choose to connect to the system when service is available, you are receiving the connection fee is paid for. But to go into this more, I've asked Larry White, who represents people in Tesuque, to come up and discuss the well rights in more detail for you. Many of your questions revolve around the well rights, and so as he's talking, I will continue to sort through these and pull out the stuff that relates to well rights. And he will answer the ones that he is able to answer at this time. And we need you to stay away from.
Yes, I'm Larry White. Basically, in your materials, if you look under section 3-2, that's a chart I prepared some months ago concerning the wells. And basically in the system, there's 4 categories of wells. One is a pre-basin well, which was a well that was drilled prior to 1956 when the basin was declared. Then there was your 72-12-1 wells that were permitted. You had to have a permit after 1956 to drill a well. And then in 1983, the district court entered what's been referred to as the moratorium. Basically, it was an order entered that provided that future permits issued by the state engineer for wells were restricted to in-house use only. Various people in like 96 objected to that, and there was a movement, and at any rate, ultimately, there was the post-1982 well settlement that was signed and approved by the court. I think it was in 1999. And so if you look at my chart, then the final category is the post-moratorium well that was restricted to in-house use only, and that did not enter into this post-1982 well agreement. Now, if you look at that chart, which is under room numeral 5, it basically tells you what you're entitled to use out of that well. Now, basically, for the pre-basin well, you're entitled to use your historic beneficial use, whatever that may have been, but in no event is it to be less than 0.5 acre-feet per year. And for those who agree to connect to the system when it's available, for all these categories of well, there's the floor of 0.5. In other words, you are entitled to use up to 0.5 acre-feet out of that well, regardless of the fact that you may have used less than that historically. Then actually, when we get into the post-moratorium wells, there's various restrictions there, and if you look at that last row, it's the post-moratorium well that did not sign the post-1982 well agreement. Basically, if you want to keep your well, your unrestricted indoor use, but if you want to use it outdoor as well, then you're entitled to use up to 0.3 acre-feet per year. Excuse me?
Aamodt case timeline in 1983 does not allow for that. It says all future domestic wells will be limited to indoor use only.
Right, that's the January 13th, 1983 order entered by the court is what that document is. And that provides that wells permitted after that date are restricted to in-house use only, except, like I said, in 1996, there was a movement to get rid of that restriction. There was a settlement reached with some of those post-moratorium wells that ended up in an agreement that allowed you to use, I think it was 0.5 or up to 0.7, indoor or outdoor. So basically that's a chart. You can look at the chart, see what kind of well you have, and that'll help you make an informed decision on what choices you want to make. One question I have here is, how do I determine what category my well is? Well, if it was drilled prior to 1956, you've probably got a subfile order that basically recognizes that well, and a lot of times I've seen them in the actual subfile order that also is an order for the surface water right. Yeah, and two, I want to point out that it's important for these individual questions to remember that we are having workshops for smaller groups of people to have these kind of questions answered. As I think Darcy pointed out, the workshops are set forth in her booklet. Okay, if you decide to keep your well in perpetuity, for example, or indefinitely, as this chart says, or agree that upon transfer of the property, your successor will connect, then basically the settlement requires you to reduce your historic beneficial use by, if you want to keep the well indefinitely, then you've got to reduce it by 15%. If upon transfer, then it's reduced by 10%. But in no event does it have to be less than 0.5 acre feet per year. And actually, I think the state has gotten well records over the last 10 years, and really very few people are using 0.5 acre feet per year out of their wells. I'll let Ted or the state address that issue.
All right. So, would you like that restated? Larry mentioned a settlement that happened in 1999, 2000. And those wells, as a part of that settlement, this is for post-83 wells, those people were allowed then to use water outdoors. And the best science that they had available to the hydrology committee that the court set up indicated that 0.7 would be a good number for people who are going to be using water indoors and outdoors. The important thing here is that those people reported their meter readings for the last 15 years. And from those meter readings, the state engineer had figured out that people in this valley typically use between 1/4 and 1/3 of an acre foot of water each year, indoors and outdoors. So when they designed this system, and I'm talking on average here, when they designed the settlement, they put a floor and said up to, except for people who didn't join that settlement and were post-moratorium wells, everybody else will get 1/2 acre foot because it's above the average use in the valley. That's the bottom. If there's a shortage, they get that 1/2 acre foot protected. People who did not join that settlement and are part of the 83 post-moratorium wells are being allocated 1/3 acre foot indoors and outdoors because it's the top number of what was used on average. So it says in there, historic beneficial use, and we have information that typically historic beneficial use is between 1/3 and 1/4 acre foot. If a person uses more than 1/2 acre foot, they'll have to reduce by either 10% or 15%, depending on which option they selected. It's confusing. Go ahead.
Did we get a water well permit issued to us for like 3 acre foot?
That's a very good question.
And now we're getting reduced because we're signing on to a water system?
What you got when you got a permit was permission to develop a water right. And it laid out a cap. You can develop a water right, but you can't go over 3 acre feet. Our Constitution calls out historic beneficial use or beneficial use. And so that's what the ultimate rule is. Beneficial use is what your water right is. The permit was simply permission from the state to develop up to that amount. In adjudications across the state, that amount is solidified and formalized to what is actually being used. I'm so glad you asked that question. Yes, he asked, how does this settlement affect the acequias? And the question I have here also, I just want to say it so I don't forget it. Do we give up irrigation rights with participation in the settlement? So, the answer is no. You don't give up acequia rights. And the settlement is designed to protect acequia rights. And you say, why? How does that work? If you sign on to the settlement, one of the things that you are getting, if you own land and you irrigate from an acequia, is priority protection during times of shortage. Okay. Okay. So we're going to talk about surface water rights for a minute, and then we'll get back to well rights. Surface water rights are, the settlement is designed to protect surface water rights. It does it in a couple of ways. One of the ways is for those people who join the settlement and accept the settlement and the decree of the Pueblos water rights. When there are times of shortage, the Pueblos will take 1/3 of their water right as the most senior. Now they're entitled to 100%, but they will say, okay, deliver to us 1/3. Then everybody else who joined the settlement will be lined up by priority date. And then the other 2/3 of the Pueblos water right will go into the lineup. And then everyone who did not join the settlement, so by priority date. So the people who will be cut off first are the people who did not join the settlement. The reason for that is because one of the things the Pueblos gave up was the right to call on 100% of their water in the first instance. So you're getting priority protection in times of shortage. And one of the things I want to explain to you is in times of shortage, you do not lose your water right. You are curtailed in some fashion, which the state engineer will be in charge of. You'll be curtailed until the shortage is over. And that may vary depending on where you are in the priority scheme. But I've heard people say, oh, they're taking away my water rights. No, they're not. They're telling you how water will be managed in times of shortage. And that was one of the big things that the Pueblos gave up, was asking for 100% when there was a shortage. The state engineer will be doing that. And the question was, who will determine the shortage? The state engineer is working on the water master rules and regulations, and that will be a part of that analysis. Is that right, Ariane? I see a nod from the corner. Let me explain something about water rights. Your neighbor cannot tell you not to take a bath. You have to take a shower, and it has to be a 2-minute shower. You have a water right, which is an amount that you're entitled to use. The tribes have a water right. They've agreed to less than what they felt they could get if they litigated it. So they took less there. They have a water right, and no one outside of the tribe has a right to say what they can do with it.
But then you're saying if we define it for those of us who have water rights for generations, you're taking away from us. Yes.
That is in times of shortage. That is in times of shortage, not in the general course of things. Wait, please. One thing at a time. All right? This man has the floor. So, well, it's true. I do have the floor, but, you know, okay. Another thing that the Pueblos agreed to do, if the settlement was passed or accepted by the court, and for people who are not a part, or who joined the settlement, is in the 80s, in that sort of time frame, the court thought for a while that it was time to do inter se, where the community weighs in on non-Indian surface water rights. The court changed its mind. That hasn't been finished yet. But in the progress of getting ready for that part of the case, there were over 500 challenges to surface water rights that were not, it looked as though that water hadn't been used for a long time. A challenge means that you have to prove up why that area wasn't irrigated, or was it irrigated and it just didn't look like it was irrigated. Challenge is not a takeaway. It's asking the court to look at a particular piece of land and make a determination as to whether or not that water right has been abandoned. All right, so this has been hanging out there for several decades. As a part of this settlement, the Pueblos agreed for everyone who accepted the settlement, they would ask the court to do away with that challenge. So what that means is you start with a clean slate in terms of challenges. This is not anything that the Indians are doing because they're mean and nasty. This is a right that everybody in this state has. They can challenge anybody's water right that looks like it has not been used because there's not enough water to go around. And if people are not using their water, someone else should have that opportunity. All right, let me move on to another question so that I can get the written down things taken care of, and then if we have time, we'll do more than that. Before I launch into that, however, where are we on domestic wells? You've been wanting to talk. Yes, sir, speak to me. No, you have about 2 minutes because there are many people. Okay, I'm using up your time.
In the first place, I would like to continue giving my livestock good water instead of treated water. We have, in some places here in the valley, we have the sweetest, the best water in the world. I've always said that instead of a water system, why don't we invest in a sewage system so that they can treat, we can get rid of that sewage and our waters can rejuvenate and because otherwise, if we run a water system in the valley, 10, 15, 20 years from now, our soils are going to be so polluted that it will start polluting the underground water, which will involve treating that water even more to be able to distribute it. In Ohio, just 2 weeks ago, in Ohio 2 weeks ago, and somewhere in one of those lakes there, one of those rivers, they had a spill and they contaminated the water, and that has happened down in the South Valley in Albuquerque. Those are things that are inevitable at one time or another when they run a water system. With a sewer system, they don't have that problem.
For you, okay? Let me answer your questions, if you will, please. Gus, we're going to answer the first question, which is why not sewer, okay? I'm going to answer your first question about why not sewer in the settlement. One of you will now approach the table. This is John Utton, and he's the attorney for the county.
Good evening. Good to see you all here. And one thing I want to say, this setting is difficult to have a dialogue. And that's one of the reasons that the county, through Darcy, is setting up, I believe it's 12 workshops, 14 plus office hours. So I think we're looking at this as trying to introduce the topic. It's going to be very difficult to answer everyone's questions in this setting because there's so many people and it's hard to have a discussion. But really want to encourage you to come to those workshops. They're limited to 30 people. If for some reason those dozen workshops are not enough, we'll schedule some more. There's also individual office hours, and you can call people of the county. You can call me. You can call Claudia Borchert. You can call the state engineer office if you want to discuss a specific issue. So we're not going to be able to answer everyone's questions today. We're really just trying to kick off this public outreach and information process. So in terms of the water system, why do we have a water system that's going to bring in water, drinking water, domestic water, not a sewage system? And the reason is, and we asked Senator Domenici that in 2001, we said, could we also have a wastewater treatment system? And he said no. This is an Indian water rights settlement, and he and Senator Bingaman and then Senator Udall were willing to carry legislation to bring in water for drinking water purposes as part of a settlement of a water rights case. And there was no money for wastewater as part of that. Now, that doesn't mean that there couldn't be other efforts, and I know the county has been looking at trying to address that question, and that really is something that should be addressed. Wastewater treatment is important, and so, it's just, you do what you can in particular settings. And what happened here is, why is there a regional water system? The Pueblos were willing to limit their claims under federal law, and Darcy has explained how New Mexico law applies. Well, federal Indian tribes have the benefit of federal law when it comes time to quantify their water rights. And that's why this case has taken so long, because of the federal law, going back even before the Treaty of Guadalupe Hidalgo, applies to Indian tribes. And this case has been about a big fight over that. And that's what we're settling. The Pueblos are essentially agreeing to take their historic use as their water right in the basin. They're agreeing to subordinate 2/3 of that for Tesuque uses. And why are they doing that? Because the federal government, Bureau of Reclamation, is going to come in and build them a water system. They're going to spend, by the time it's built, over $200 million doing that. Pueblos are going to get 2,500 acre-feet of water from the Rio Grande that's brought in. Darcy described it as making the pie bigger. And in exchange for doing that, the Pueblos are saying, okay, we're willing to reduce our claims in the basin. We're willing to subordinate some of our priorities. Well, the county and the state looked at that and said, the federal government's going to build a $200 million water system. They're going to spend that. Senator Domenici, he came through. Senator Bingaman came through. Senator Udall. And right at the critical moment, Congressman Ben Ray Lujan came through. He was one of the key people on the House side that brought that through. And so the federal government's going to build that system. And so the county said, well, do we want this to just be a Pueblo-only system? They're going to run lines all through the valley. They're going to run them all the way up to Nambe. They're going to run them all the way up to Tesuque. And if a county resident who is not a member of the Pueblo wants to hook into that system, should they be allowed to? And the county felt strongly that this should be available to any county resident, whether you're a Pueblo member or not. And the state felt that way. And so the deal that we struck was that we could upsize the system. And the way it's going to be paid for is we're only paying the marginal cost of making the system a little bigger. And the state is coming up with $50 million to do that. So we wanted this to be a system available to any county resident who wants to hook up. The settlement doesn't require anyone to hook up. It's optional for you to do that. And so, this is a settlement where there's some give and take. The Pueblos have senior rights. And so this was really a difficult process, really a bit of balancing to try and make sure that as much as possible the status quo is protected. But it's a basin that's short of water. Everyone had to give a little, and that's what the settlement proposes to do. No one walks away from the settlement with everything that they want. It's a complicated settlement. You read these documents, and you think, oh my God, who put all this together? And you can see that a lot of different views had to be reconciled in the settlement agreement. So you walk away from the meeting today. One thing I want you to know is that there are really two different decisions. There's a question of, do you object to the settlement overall? Should we just throw it out and continue litigating? Should the Pueblos go back to asserting large federal claims? Should the money that's going to come into the basin, should that just all go away? That's the deadline on April 7th. That's the objection deadline. If you think that we should just throw all this out and start over again, then go ahead and object. The other decision you have to make is, if I'm a well owner, how do I want to fit into this? Do I want to check the first box and sign up for the county water utility when it's available? Do I want to keep my well? Now, of course, if you keep your well, you can still hook up later, but you might not get some of the other incentives like a free hookup. But it's your decision. But that decision you don't have to make.
Why don't you tell them that if they keep the well, then we'll have to cut it out to 25 acre feet of water instead of 3 acres that they have now.
Okay, so the way the settlement is, okay, let me.
You're taking out away 2.5 acre feet of water from people, that's stealing water rights.
All right, so you don't have to go down to 0.5 acre feet. No, you don't. No, you don't. If your historic beneficial use was 3 acre feet, let's say you actually put 3 acre feet to beneficial use, and that is your water right. And then you check the box. Let's say at some point in time you actually use all 3 acre feet. Then that actually would be the measure of your water right. If you sign the settlement, and depending upon which box you check, you would be agreeing that in the future you would reduce that to either 90% or 85%, depending on which of those two boxes that Mr. White explained.
That's not true because the state engineers sued me to get 0.5 acre feet of water. They're not telling me that if I can use 3 acre feet of water, I can use them.
Well, it depends on which category you're in. It is complicated, and that's why you should come to these workshops.
It's not complicated because what you're doing is stealing water right from us.
Okay, well, let me just tell you, from the county's perspective, the county came into this not to steal anyone's water rights. The only reason the county came into this was to help with a major public infrastructure. Well, you don't have to check the box to connect. And if you oppose the settlement, you can object. I think. Okay, if you disagree, as I said.
I worked on a project up here in Buckland back when I was a young boy in 1972 for Ken Noe Construction. We ran a 20-inch pipeline from Buckland over here by close to Exxon all the way to San Jose. And I was told by the state engineer's office, and when I went to investigate on that those valves and the booster stations were constructed, were built on no man's land. There ain't no such thing as no man's land anymore. That's what I was told. How powerful do they think I am?
So I think the bottom line is, excuse me, sir.
Sir, you have had your opportunity.
All right, I think the bottom line is everyone has to make their own decision. And the main point I'm trying to make, though, is that if for a well election, there isn't a current deadline for your well election. The court hasn't set that. That's probably going to be a year or more off. I think as Darcy mentioned, this order that we're expecting in May or June, we'll set a deadline for that. So I think what we're trying to do is give people information so they can make their own decision. We're not trying to force anything. People make their own decisions. That's completely up to you what you want to do. If you want to continue opposing the settlement, it's been a difficult negotiation. I think we have done what we can. If you disagree with it, you can object.
What's the next question?
So, let's see. There's a question for Claudia Borchert.
Claudia? All right. People took the time to write down questions, and I would like us to be able to answer those questions. If you have additional questions, we're running out of time, but there are other opportunities for you to ask those questions. So I would like us to be able to address the questions that people have written down.
This is a question that says, who will own and operate the county water utility? Who will I have to mail a check to for my water? So this is the portion of the water system that delivers water to the county customers, non-Pueblo customers, will be owned by the county water utility. So the person that you would mail a check to, should you choose to become a county customer, will be the county water utility. We currently have almost 4,000 customers, and so the customers that would elect to become part of the county utility will be one more or several more than the 4,000 we already have. We went back and with the current rates, if you use 5,000 gallons, which I think is probably more than the average user, your monthly bill would be $45.
All right. Remember that you do not have to connect to the system. You can keep your well. And the amount of water that is being identified is within what the records show that people typically use in this valley. Let me say before I forget, Commissioner Mayfield wanted me to mention that this videotape that's happening right here will be on his website if you wish to take a look at it. Do we give up irrigation rights with participation in the settlement? No, you don't. Let me get through these questions, okay? Where is the office for the office hours? That will be in the Pojoaque satellite office, which is near True Value and near the grocery store. The office hours will be 6 to 8 on Wednesdays and 10 to 2 on Saturdays. And those start next week. We have some, let's see. Oh, someone wanted to know if I have a surface right and I have a well right, can I use the same piece of paper? The answer is yes. If you have more than one well right, you need to provide the information about both wells, or all 3 wells, or however many you have. I would like, there have been a lot of questions about domestic wells, and I would like Ted Bagley to come up and address some of those questions for you.
Oh, thank you, Darcy. I'm going to do my best to try to read these while I talk. The first one here is, who is responsible for determining how the water system will impact the water level my well is currently at? That seems more really a system question for the county because it's a surface water system. There'll be supplemental wells in the valley, but the plan is the water is going to come off the Rio Grande, so it's not going to have impacts on individual wells. Pardon me? That's not the plan. There are EPA standards that have to be met, and there'll be treatment facilities. As there are everywhere in the country. There are standards that have to be met for that. Pardon me? That I don't know. You'd have to ask the BOR about that.
That project is ongoing right now, and on my website is in fact a link to that website so that you can track it, and also there are maps on there, there are schedules on there, and so the contractor with the Bureau of Reclamation is engaged in that process right now. It needs to be finished sometime before 2017.
The first is what will determine if the settlement fails. And there are a number of conditions that have to be met for the settlement to succeed. One is, of course, to be approved by the court, and that's the process we're in right now. The objection process, it'll probably take 18 months to, a couple of years, depending on how much litigation comes out of it. That has to be approved. The pipeline has to be constructed. That's a condition that has to be met. Funding has to occur. There are a number of items in the settlement. I'm afraid I can't bring them all to mind, but there's state legislation has to be passed on several issues that are required for the settlement to work, and things like that. But as I said, there are several items that are in Section 9 of the settlement agreement, and of course the Utton Center has all these answers at a telephone call away. Let's see, do non-Pueblo lands acquired by the Pueblos fall under the same restrictions as do the non-Pueblo users, both surface and groundwater? And I'm afraid that's that would be a case-by-case thing. I think it would depend on the particular land and the particular water rights that we're talking about. If they're state-based rights, they would be, presumably have the same limitations, but it'd really be hard to give an opinion on that without knowing more. This one, I think, was one of the ones we just answered. When a person owns 2 or more wells on different properties, can they elect to accept the settlement on one and decline on the others? They can accept on one and not accept on the others. They can't accept on one and object on one of the others. You have to choose one or the other. And then there's a question here with an asterisk. Why will it says, why will the objectors not be protected by the state engineer? Will we still have our water rights? The answer to that is yes. There's nothing in the settlement that causes anybody to lose a water right, and whether you object or don't object to the settlement will have no effect on what the state engineer, how it administers or adjudicates your water right. And how will historical beneficial use be calculated, Darcy's asking me, and that's one of the items in the settlement is that it requires metering of all water uses, Pueblo and non-Pueblo, all types, and that'll provide information about historical beneficial use. And I think, who do I contact to update my well information? For somebody who didn't get a packet, packets are available. There are a lot of them here tonight. There'll be packets at the meeting on Thursday. The workshops, presumably, I'm assuming there'll be packets at the workshops as well. In terms of updating your ownership and address information, that's over in Water Rights Division. Vince Chavez and Brian Gallegos and Steve Mastovich from the office are here tonight. They don't have update forms with them, but they'd be the people that you would talk to when you come into our office. That's in the Baton Building across on Capitol Avenue, just right by catty corner of the Roundhouse, and come in and they do that all the time. And I think, oh, here we go. You said we will be cut off. I want to know exactly what that means. Well, nobody's saying anybody's going to be cut off. Any idea who asked that question? Could you elaborate a bit on that? Okay.
Excuse me, Darcy, right? You were the one that said something about that the people that did not agree to the settlement, that they would be cut in times of extreme drought or whatever, they would be cut off.
Curtailed is, if I said cut off, I misspoke. What I meant was curtailed. The details of that will come in the Water Master Rules and Regulations. Do you want to say that?
Well, not so much that, but yeah, curtailment, it doesn't mean cut off your water right. It means, this is the status quo now. If somebody has a better priority than you in time of shortage, they can say, we should get the water. We're not getting our water because you, with a junior right, are getting water. And if your junior right is curtailed at that point, then I would get my water, and that's what it refers to. That's the system of priority administration that exists throughout New Mexico, and that's the situation today. That's not something new with the settlement.
And curtailed doesn't, it can mean cut back. It will depend on the particular situation. It can be, I tried to illustrate with, I don't water my lawn anymore. I am curtailed from watering my lawn because there's not enough water to serve people. So let me get this one question here because I think this is an important one. And if you want to talk about that further, I'm happy to do that. What percentage of the valley would have to object to the water system to be canceled? This is not a voting thing. What you would have to do is object to the settlement and the decree, and then the court will decide whether or not to adopt the settlement and the decree. So it's up to the court. It's not a matter of numbers. It's a matter of the quality of the legal argument and whether or not the court accepts what you have to say. I'm sorry?
Not some people to look up and object.
Let me get someone to answer that question. John? John Nutton?
So the objection is unrelated to the building of the water system unless the court ultimately just throws it all out. So as I was saying before, if you oppose the settlement, you can object. That's not going to be taken as the water system isn't going to have customers that are going to want the service over the next 100 years. The county, along with the money that the county is getting from the state, has made the decision that we want this system to be available for all county residents, not just Pueblo members. And what's driving the sizing of the system is fire protection. So one of the important benefits is that it will be available for fire flow, and that actually means that there will be lines, distribution lines, and if people want to hook up, they can. So we're not counting people here and counting people there. The system is going to go in, and over time, people can hook up to it, or they can hook up now.
As far as you're concerned, is it going to be classified or recognized as a co-op instead of somebody's form of making some kind of revenue out of it? Is it going to be a co-op for the people of the valley?
So,
Co-op, just like the valley, co-op.
it's not going to be a co-op. The county water utility is going to provide the service. So it's a public entity. It's not a profit-making entity. It's a public entity, just like the water utility that Claudia Borchard described that exists today. The county would just be expanding its water utility services.
I have a question here. Is there any credit for gray water, black water recycling? I don't know. I haven't thought about that question. And I would suspect that that's something that the state engineer could address in its regulations. And I would encourage whoever asked this question to bring it up when it's time for evaluation. Ted has another moment in the sun. And as he's approaching, I want to tell you a little bit more about the court process. The court wants each of you to either accept or object. If you do not accept or object by the next deadline, which is the acceptance deadline, the court will send out another order to show cause and try and reach you. If it cannot reach you, you will be deemed to have accepted the settlement, and that you will connect to the water system if it ever becomes available. So you want to respond to the court. And so that means filing one of those two documents, expressing your desire one way or the other.
Does it have a certain amount of majority to get past the three-quarters majority?
No, this is not a voting thing. This is not a voting thing. The court will weigh the arguments and it will make its decision. So your conversation is with the court about whether this thing goes through or not. This young man with the mustache is going to tell you the answer to that question.
Those haven't been developed yet. At the JPA, the Joint Powers Agreement, the Water Master Rules and Regs, and the Operating Agreement, I think, so one of the ones you said, right? The state, we're currently working on the Water Master Rules and Regs, and hopefully we'll have something that folks can look at sometime in the course of the next year. The JPA, I'm not so sure. Well, it's a complicated document, and it takes a lot of work to do. I think the answer, your concern is about entering into the settlement without knowing what's in those documents, right? And that's one of the sort of artifacts of the order to show cause. If you look at the order to show cause, the court has a deadline for objecting to the settlement. It says if you object to the settlement, you have to do it by April 7th. That's because the court needs to allow enough time to work through objections to the settlement in the court process. It has to have a deadline for that now. If you want to accept the settlement, there's no backstop on that. So I can't guarantee when these documents are going to be done, but you know, there's the deadline has not yet been set for the court to accept this, accept the settlement, so you can, you know, wait and see what develops with those. You can withdraw an objection. I don't think you can withdraw an acceptance. Yeah.
What was that?
Negative. No. There are documents that haven't been developed, but they're based on a settlement. So what the settlement says is what, actually, I'm sorry, let me back off on that statement. The JPA, my agency is not involved in, and that's not, there's nothing in the settlement that dictates what's going to be in the JPA. So, pardon me? There's no answer right now on the joint powers agreement with regard to the, and I want to distinguish that from the rules and regulations, because the rules and regulations are based on what's in the settlement. So the rules and regulations are designed to give life to that. So, you know, the settlement tells you what's going to be in that. You do have some idea. The other thing that was mentioned was the operating agreement, and without final design for the project, an operating agreement can't be put together. I mean, until you have something to operate or a design for that thing to be operated, that document can't be put together. And the settlement agreement and the legislation that approves it requires this, you know, sort of progression of document development. So it's, you know, what you say, I guess, is to some extent correct, to some extent not, because the settlement describes many of the things that, you know, would answer those questions. But at this exact moment, I'm listening to you.
I mean, everybody here in the whole valley, I mean, of course, gotta listen to the people.
Which is exactly what this is about. There are 2 of these large meetings and 12 workshops to do just that.
And the court is giving you that opportunity to tell it what's going on, but through this objection process.
Right now, it's not happening.
Your deadline is the 7th of April.
Of course, I'm not listening to the people.
I understand, and we're going to move off that point right now because we need to answer other questions. I understand your frustration with the courts. This is the opportunity being afforded to you.
Let me see, I just wanted to add 2 different people over here, Arian Singer and Commissioner Mayfield, just wanted me to point out 2 things. One, on the water master rules, that there's going to be a full public process of promulgation of those, where opportunity to comment, and so there'll be a whole other public process on that. And then Commissioner Mayfield, who has been urging the county to move forward with the joint powers agreement and get that done as quickly as possible, wanted me to point out a couple of things about that. One is there will be a public process for that document for public review and comment as well. In fact, Commissioner Mayfield sponsored a resolution that requires that, and so there will be a draft joint powers agreement that will be available, and we'll go through a public process, I'm thinking this summer, and that will go then in front of the Board of County Commissioners for approval probably in the fall, I'm thinking, and that's going to be well before anyone has to make a well election. So you'll know what that joint powers agreement looks like. One of the things that I think I just want to leave you with one thought about that is that the operating agreement and the joint powers agreement, they're very constrained documents by the settlement agreement and by the federal law. The federal law, in fact, has a whole section on what has to be in the operating agreement, requirements that water be delivered from the regional water authority to the customers. So there's very little discretion. You know, people ask me, well, why? You know, what's going to stop the board from just cutting off our water? Well, the settlement agreement approved by the federal court, the governing federal law that was approved by Congress don't allow that. They require the water to be delivered. And so this board that is going to be created by the Joint Powers Agreement is going to approve a budget. They're going to hire an operator. Probably the most important thing they're going to do is they're going to hire an operator, because this board's not going to run the system. And although we don't have a final draft of the Joint Powers Agreement, the Pueblo leadership has agreed with a provision in the Joint Powers Agreement that the county would be the operator of the entire system on both Pueblo and non-Pueblo land. So from the river to every customer, Pueblo and non-Pueblo, the current document states that the county utility department, so Claudia is going to have a big task of running the whole system. And so that is what we're expecting when we finalize that document, and you'll have a chance to come and look at that this summer, that's what it's going to say, that we're going to have a real regional system where we have one operator, and since the county already runs a water utility, that the county would be that entity. So people will have a chance to see that, get more information. You do have a deadline coming up of April 7th to decide whether you want to object to the settlement or not. You don't have to file your acceptance yet. You don't have to make your well election yet. You can wait and decide. And if at that time you still feel you don't have enough information, or for whatever reason you don't want to connect to the system, you don't have to. It's entirely up to you.
Now then, we have no minutes left. I would encourage you who have additional questions to call me. I will do my best to give you neutral answers. And I want to thank you all for coming this evening. I encourage you to come to workshops and drive carefully and safely on your way home.